I'm not threatening you. Say one more word, and that's 30 days. 30 days.
Hey, what's going on, guys? Welcome back to Sovereign Citizens Hall of Fame with your man TP. Today, we are jumping into number 244 on our compilation list. As always, it is a pleasure to have you guys joining me here at Sovereign Citizens Hall of Fame. Before I give you the judges' names of the courtrooms that we will be in on today, don't forget to like, comment, share, and subscribe. Also, commentary will be left in those proceedings that had commentary, and chapters will be added for your convenience. Now, the judges' courtrooms that we will be in on today. First, we will be in the courtroom of Judge David Ricke out of the state of Kansas. Second, we will be in the courtroom of Judge Colin Hunter out of the state of Michigan. And last but not least, we will be in the courtroom of Judge Guerrantt out of the state of Georgia. As always, guys, it is a pleasure having you guys join me here on Sovereign Citizens Hall of Fame. It's about that time. Let's go ahead and jump into this compilation.
Okay, why is there a Juan Flores on this meeting? There's no response. Okay, whoever's Juan Flores's box is muted, so I'm not hearing anything. They can unmute themselves if they've got some business with this court.
Hi, Judge. I am Counselor Flores, and I am resident McLaughlin's counselor, and they have him here right now.
Okay, very good. Thank you.
Yep.
Jesse Travis McLaughlin.
Yeah.
It's the state of Kansas versus Jesse Travis McLaughlin. It's case number 2024 CR 397. Mr. McLaughlin appears from a Hutchinson Correctional Facility Zoom location. Brett Sweeney appears for the state of Kansas. Mr. McLaughlin, I have before me a charge of battery against a law enforcement officer, a level 5 person felony. Since a felony is involved, we will not be asked to plead at this time. Rather, a preliminary hearing scheduling will be made before your assigned judge, which is the Honorable Jan Satterfield. Judge Satterfield's next docket for that purpose would be April 7, 2025, 2:30 p.m. You must fully participate by Zoom in Judge Satterfield's docket at that time, April 7, 2:30 p.m. I trust, Mr. McLaughlin, that you, being in prison, don't have the financial resources to hire your own lawyer.
That's all right. I can represent myself.
Okay, well, you can take that request up with Judge Satterfield. At this point,
Every
in
man
the
must
abundance of
speak for
caution,
himself, Your
I will
Honor.
appoint a lawyer, and then you can, before Judge Satterfield, properly conduct a proceeding if you really do want to
Point of
represent.
order. What gives you jurisdiction to appoint a lawyer over me?
I have statutory authority to do so. So, Mr.
So
McLaughlin,
what
I'm
gives
going to
you
appoint a lawyer at this
what
point.
gives you jurisdiction over me? You must establish jurisprudence as a point of order.
I'm not going to play your sovereign citizen gibberish game.
I'm not a sovereign citizen, sir.
All
I'm not a
right.
sovereign citizen.
You sound like one.
Well, I'm not.
All right. I assure you I have jurisdiction. So we've got a court date set before Judge Satterfield. I'm going to appoint James Watts at this point to represent Mr. McLaughlin, noting he's made a request to represent himself. Again, that's to be a matter taken up fully before the assigned judge, Satterfield, at the hearing date on April 7 at 2:30 or some later time. And the court will set a $5,000 cash or professional surety bond, though obviously it's not going to affect his current incarcerated status. All right, bond set, attorney appointed, court date established on Judge Satterfield's calendar. Anything else we need to address at this time, Mr. Sweeney?
No, Your Honor.
Mr. McLaughlin? Apparently not.
Yeah, you need to address the point of order. As a
I've
first
addressed
point
all
order
of
in
the points
court
of order
the
that I'm
first
inclined
thing
to
you
address
must
today.
do is establish
Mr.
your
McLaughlin.
jurisdiction.
The McLaughlin matter is currently in recess, and we'll move on to another matter on the docket.
I object to moving on in any manner.
Objection noted and overruled, Mr. McLaughlin. All right, let's move
Request a
on.
copy
Sorry,
of-
Ken.
I
Thank you
request a
to the
copy of the
Hutchinson
minutes,
Correctional Facility.
transcripts, these proceedings.
We can go ahead and take him off the meeting at this time.
Thompson.
That is the person that I was given to use in this life. And that proper style is upper lower case in accordance with SPR 89363, which is a court order to full faith and credit.
I'm going to speak one more time and then I'm going to allow a response. The answer is either going to be yes or no, and the answer to that question will determine whether or not you're involved in this hearing or not. But I don't allow ridiculous comments to be made, and I don't allow litigants to control the method of this court proceeding. Instead, I ask simple identifying questions because I've just called a case, and the case is called Katrina Thompson versus David Thompson. If the answer to the question I'm about to ask is yes, you're going to be entitled to proceed and be heard in this case. If the answer to the question I'm about to answer is no, you're not associated with this case and you won't be able to be heard. So the answer to the question, is, are you David Glenn Thompson?
I am that living soul allowed to use that? Yes, I am that soul.
Mr. Thompson, it's either a yes or no, or you're not going to be involved in the hearing. Let me take it a step further and let you know what happens if you are not David Glenn Thompson. My next question will be, is there any other David Glenn Thompson in the courtroom or otherwise? If I hear the answer to that question, no, it's likely that the court will issue a bench warrant for non-appearance. So it's your last chance to tell me.
Sure. Yep. Yes.
Are you David?
I feel really coerced right now. Thank you. I appreciate that.
Are you David Glenn Thompson?
I believe I just answered that with a yes, and I feel really coerced right now.
Mr. Thompson, I'm not going to allow ridiculousness to control the day in this court proceeding. I don't view this office as needing to allow that, and the law doesn't view this office as needing to allow it. I have a simple and straightforward job to proceed with. If you make that job difficult or impossible, I'm going to simply remove you from the hearing because I don't need to hear ridiculous commentary from you. So when I ask you if your name is what you're listed as on this docket and you tell me you feel coerced, I respond by indicating this. You can participate in this hearing if you're reasonable. If you're not reasonable, I'm going to remove you from the hearing. Am I clear?
Well, I do apologize. You're very clear. I'm just trying to correct errors upon your record.
This record, again, Mr. Thompson, is clear, and it will be more clear if you let me proceed further past what should be fairly innocuous, which is whether or not you're a named party. Now that we've gotten past that rather innocuous, fairly clear point, the next really clear point is this. You're here today, Mr. Thompson, because there's an allegation that you've not been paid to support as ordered by the court. If you're found to have not been making reasonable payments out of your available income, the court could hold you in contempt, and contempt is punishable by potential jail. In this case, we're also here to address a bond that you had previously posted. So when you posted a bond, I ordered that a hearing would be set today. When I set that hearing, it's to address several things. Number one is to address the issue of contempt and whether or not I should forfeit the bond that you previously posted. The order specifically indicated to you why we're here, but because there appears to be difficulty in you understanding that, I'm going to go through it. Defendant is required under the terms of that written order that you got a copy of to show cause why you should not be held in contempt for failure to comply with the court's order. If you fail to appear, you can be found in contempt and a bench warrant can be issued. If contempt is found, the court can apply any enforcement remedy allowed under the law. The bench warrant is discharged. So again, that's the requirement of the prior order. It enunciated clearly that you were going to appear here on December 5th, and I'm glad that you're present to be able to address those issues. So Ms. Spillane, let's start with the bond. From the friend of the court standpoint, are you asking the bond to be applied towards any outstanding arrearages?
Yes, sir, we are.
Mr. Thompson, did you hear the suggestion by the friend of the court?
I did, and unfortunately, I did not put the bond up. A friend of mine put that up. I prefer to go back to them.
Well, the bond is required by statute, Mr. Thompson, and the reason it's required is because when you have outstanding arrears, The law says that if I issue a failure to appear bench warrant, as I did in this case, that I have a statutory duty to impose a bond in the amount of 25% of the outstanding arrears or higher based on my determination. So the amount of the bond that was posted on your behalf is going to be ordered to be forfeited towards the outstanding fines and outstanding child support arrearage. I understand your request, but I'm also confident that the person who posted bond in this child support related matter was, is, or should be aware of the fact that when posted, it couldn't be utilized for those purposes. So I note your objection, but I rule otherwise in order that the bond that was posted will be forfeited towards the ongoing support obligation and or any arrearages. Once that's done, Ms. Spillane, can you tell me in general, what is the outstanding arrears, if there are any, and what is the outstanding monthly support obligation?
Your Honor, this is an arrears only case. Once that bond payment is credited to his account, the total balance would be $14,833.05.
And does friend of the court have any suggestion on what we should do outside of having the bond forfeited as I've ordered already?
We would like to refer the defendant to the referee to monitor payments going forward.
Mr. Thompson, did you wish to be heard on that suggestion by the friend of the court?
I don't even know what to say. I don't really feel that it matters what I say. You just do what you want. So, I mean, I'm looking at court orders in front of me. I'm looking at House Resolution number 10 saying, you know, you can't ask for money because of the bankruptcy. I don't even believe this is an actual Article 3 court. But hey, here we are. And I'd like to know what happened to the promissory note that was sent in 2017 for $20,000 gold equivalent. Registered mail to Clerk DeViter, I think it is. And why that wasn't credited to the account. Since that would be a securities under these laws here.
So the court would note that I've exercised my discretion to mute Mr. Thompson. I'm going to do my best to explain why. This court proceeding has started difficult. It appears to be proceeding difficult, but it's really not a difficult understanding or case to understand in terms of the background. The background is that years ago, this case was instituted. It's a 2017 case number. It was instituted as a support matter. As the Ms. Blaine just indicated, this is a support arrears only matter, which means there's no longer any support that's currently charging, but there are outstanding arrears. Arrears means, of course, that there was a prior court order, and that court order was for Mr. Thompson to pay support. Mr. Thompson either did challenge that and was found not to have a legal challenge to that amount, or he didn't challenge it. And either way, the amounts have been, for years, been determined to have been owed. The amounts have not been paid, however. And even after this $5,600 bond has now been forfeited, the total of arrears are $14,833.05. That's not an insignificant amount. When pressed on that issue or questioned if he wanted to be heard, rather than be heard on what the friend of the court issued, which is a fairly, I would say, insignificant request to have the payments going forward monitored through a referee process, Mr. Thompson chose instead to bring up things that have nothing to do with this case. For example, I think, rather oddball claim that this is not an Article 3 court, or things referencing a surety contract or other words that, although they seem quasi-legal, don't bear any particular relation to this case. And so the court is left with the suggestion of the friend of the court on what appears to be a fairly innocuous arrears-only matter. And I keep saying fairly innocuous to the court. This is not a difficult factual determination. It's not a difficult legal determination. An order was apparently in place. It ordered Mr. Thompson to pay. He's not done so. Arrears are in the nature of almost $15,000 after the bond was applied, and yet there's claims about promissory notes, and other words that I've heard but don't understand how they have any relationship to this case. And I'm quite confident on the record that's been made so far, if I allowed Mr. Thompson to be heard further, I would become more confused, not less. And so it's important for me to note that every opportunity is given to litigants to be heard. Those limitations, some limitations on that right to be heard are present in this case, and that is I allow litigants to be heard if it's responsive to the question set forth. If it's not responsive or relevant to the question set forth, I don't find it helpful. And I wouldn't find it helpful if the friend of the court offered things that weren't relevant to the issues at hand either. So again, the court has exercised its discretion To bar any further oral argument by Mr. Thompson, instead I'm going to follow the suggestion in front of the court. I'm going to refer this case to the referee docket for continued maintaining and watching over whether or not these payments are made going forward. I will, of course, maintain jurisdiction over this court, over this case. I'm simply referring this case to the referee for further proceedings, and I'll also sign that order once it's presented by the friend of the court, ordering that the bond that was posted on Mr. Thompson's behalf is forfeited towards the outstanding arrears only in this matter. Do you have any questions, Ms. Boyd, on this case?
No, sir.
All right, thank you. The court is at recess on this matter then.
Well, guys, we have come to the end of this proceeding. And as we can see, Judge Hunter absolutely was not having any of the silly stuff that Mr. Thompson thought that he was going to bring to the table. He definitely tried to play games with the script that he had. He kept lifting up his paper. But as we can see, Judge Hunter was not having it at all. And it seems like the two words bench warrant were like a splash of cold water in Mr. Thompson's face, because as soon as he said those two words, it seemed like it snapped David right out of whatever game that he was trying to play. He seemed like it woke him right up, and he kind of, got himself together and realized, like, listen, this is not a game that you want to play. We see that he owed about $20,000 worth of child support, which now the bond that was posted, according to him, by a friend, and if it was posted by a friend, hopefully that friend read the fine print. But now that $5,000 to $6,000 that was posted, according to him, by his friend, it could have been by him, and maybe he felt by saying that it was a friend that posted it that they wouldn't touch it, but it was a part of the bond conditions. Now he owes about $14,000 in child support. But once again, this was my first time in Judge Colin Hunter's courtroom, and I definitely see he's not going to play any games with anybody, because he was quick with it. He didn't even give it a second thought to play any type of games with it. And I know a lot of you guys out there, that's how you like it. So with that being said, guys, if we have a follow-up on this particular case, we will definitely share it with you guys. And that's pretty much it for now. This is Sovereign Citizens Hall of Fame. And for now, guys, Sovereign Citizens Court is adjourned. God bless.
That's 16 with Miss L, Mr. Saunders. All right, so Miss Germany, Miss Saunders, and Miss L, Mr. Saunders, I'm sorry. If you could all please unmute and raise your right hands. I'm just going to swear everybody in. Miss Germany, if you could unmute for me. You're muted.
Sabrina, okay.
There we go. All right, thank you. Miss Germany, if you could please raise your right hand. All right, do you all swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth under penalty of perjury?
Affirm.
Okay, thank you. All right, thank you all. You can all put your hands down. Okay, so I did previously review the case. Mr. Saunders or Miss L have filed several documents. I'll let you make your presentation, but I don't see that they're actually responsive to the petition. I'm going to let Mr. Duda put on his case, and then we'll go from there.
Yes, Your Honor. We would initially file for a motion for judgment on the pleadings, but I'll, Sabrina, if you can unmute, please. Sabrina, there you go. Sabrina, Germany, can you please state your name for the court, please?
Sabrina, Germany.
And with whom are you employed?
Invitation Homes.
Okay. And is Invitation Homes currently the management company for SFR XII ATL owner 2LP, the plaintiff in this case?
Yes.
And when did Invitation Homes, is to the best of your knowledge, is SFR, is the plaintiff the owner of the property located at 4348 Carrollwood Drive, Stone Mountain, Georgia 30083?
Yes.
Okay. And when did Invitation Homes begin managing that property for the plaintiff?
December of 2023.
Okay. And to the best of your knowledge, do the defendants, Tenkia Hodges and Jared Saunders, are they the named tenants on the lease for that property?
Yes.
Okay. And what is the current monthly rent for that property?
$2,195.
Okay.
Base rent.
And pursuant to the lease, are late fees allowed to be charged after what's the late date stated in the lease?
Yes.
And what's the amount of the late fee?
10%.
Okay.
$219.50.
Okay. And since December 1st of 2023, have the tenants made any payment towards the rent in this property?
No.
Okay. And what is as of today, including May's rent, what is the current amount due?
$15,384.98.
Okay. And
What would it be through,
I would need to prorate that real quick, Your Honor. I should have been doing that when I was waiting, but I didn't.
that's all right. That would be the 22nd.
And see. Okay, so the prorated amount through the 22nd is $1,557.74. So subtracting, let's see.
What was that number again? The prorated amount?
Yeah, let's see. It's $1,557.74. So the current balance prorated through the 22nd is $14,747.72. That does include a late fee for May. I'm not sure if the court allows late fees after the filing of the case, though.
Since it's a prorated, why don't we just take that off? That's $219.
Okay. Yeah, so that would subtract an additional $219.50.
$219.50. So that's $14,528.20.
That sounds right, yes.
Okay. All right. And that represents rent from January through 22 days in May, minus the late.
That would be from December of 2023 through May 22nd, right?
Oh, so the last payment was actually in November?
My client, Invitation Homes, took over management of the property on December 1st, and at that point in time, they just treated it as a zero balance and went forward from there. No payments have been made since my Invitation Homes has taken over management of the company or the property.
So no payments were received in December?
Correct.
All right. And the monthly rent is $2,195?
Correct.
Okay. All right. Anything else?
No, I believe that's it, Your Honor.
Okay. All right. So Ms. L and Ms. Saunders, I can't have you go at once, but Ms. L, if you have some questions for Ms. Germany, you can ask her some questions now. You don't have to ask her questions, but if you wanted to ask her a pertinent question about her testimony, you can do that.
I mean, Judge, I stand affirmed that documentation I did not submit, but that did retrieve later, does not affirm the information that she stated true, correct, and complete. That's why I recorded an affidavit of truth, correct and complete to the court.
Would you want to ask her any questions, though?
I have no questions for her.
Saunders, do you have any questions for Ms. Germany?
No, ma'am.
Okay. All right. So Ms. L and Mr. read through all the documents that you presented. I'll let you make a very brief statement about it if you want, but as long story short, they do not present a legal defense to to having signed the contract and being obligated to pay rent in this case. So that doesn't, none of the stuff that you put in there is going to be a defense to that. Like I said, if you want to make a brief statement, you can do that. But outside of that, that is, after having read through all of the paperwork you submitted, that is my position based on what I've read that you put in. But so if you want to make a brief statement, Mr. Saunders, if you'd like to make a brief statement after that, you can do that. Ms. L, if you'd like to go first.
As I said to Judge, I sent the affidavit. I take full liability under oath. You know, with the demands listed for the plaintiff to rebut point for point as a counter affidavit. The plaintiff didn't rebut the point for point under oath, under penalty of perjury, which means the affidavit stands as true. Also, Judge, this affidavit stands as judgment in commerce in a tribunal or court. The plaintiff also was using my information, my personal property that I have a claim to. If you see page 2 of Exhibit C and Exhibit B, pages 1 and 2, it states that information.
All right. Mr. Saunders, do you have any statement you'd like to make?
Yes, I affirm that I'm a witness to everything she has stated in the documents in the affidavit and putting her lawful identification on the record. Everything is notarized, true, correct, and complete, and she does take full liability for everything stated and the validity and veracity of everything stated in the documents.
Okay. All right. All right. I think that Mr. Duda, do you have anything else?
No, Your Honor, just if the court is going to issue an order in our favor, there is a mention of, in their response to some $500,000. I'm not sure if that's considered a counterclaim or not, but we would ask that the court basically deny any asserted counterclaim.
I did not interpret it as a counterclaim, but
okay.
If it is a counterclaim, I will deny it. So I will issue an order today. I do find that there is a valid lease between the parties and that the amount owed, that there has been no rental payments made since December of 2023. I am not allowing a late fee for May, but rent, including late fees, 80%, will total $14,528.22. I will go ahead and issue that order. And unless anybody has any questions, you are all free to go. Go ahead, Ms. L.
Thank you, Your Honor.
Judge, I am asking the Honorable Judge of the finalized contract between me and the plaintiff for the amount stated in the first part of the Exhibit A.
Okay. As I mentioned before, I did review all of your documents. They have no legal validity, and that is my finding. So I'm going to go ahead and issue an order in this case. You are all free to go. You will get a copy very soon of the order. Okay? All right. So Mr. Duda, Ms. Germany, Mr. Saunders, and Ms. L., you are all free to go.
Thank you, Your Honor. Have a good day.
Yeah.
Thank you. Have a good day.
I'm not threatening you. Say one more word and that's 30 days. 30 days.